side will have 15 minutes. You may reserve up to 5 minutes. And we're ready to proceed.
Thank you. Good morning, Your Honors.
Good
My name is
morning.
Brett English. I represent Heather Sayler. I also represented her in the trial of the case. And I would like to reserve 3 minutes of my time for rebuttal.
Thank you.
Your Honors, this case raises several interesting questions arising from a prosecution against my client for allegedly driving under the influence of alcohol and failing to maintain control of a motor vehicle. The first issue in the case, let me just set the stage if I can. Early in the morning at approximately 5 o'clock a.m. on March 18th, 2015, a motorist was coming northbound on Interstate 71 and claims to have observed another vehicle, a white SUV, purportedly driven by my client, but that's where one of the major issues is. Hit an icy patch, go off the side of the road, and then go across the road and hit a median. This motorist could not identify who was driving. The motorist could not identify whether the driver was a male or a female. The motorist could not identify who else was in the vehicle and knew nothing more about the matter other than what I have just explained. He called 911 to report an accident and then kept going toward Cleveland Hopkins Airport. This individual, whose name is Morris, testified at the suppression hearing in the case. The evidence is that several police officers came to the scene. Only one of the police officers testified at the suppression hearing, a state trooper whose name is Duda. There is another officer from the sheriff's department who showed up, and here is what the evidence was at the suppression hearing. A woman named Heather Sayler, my client, was in the back of the deputy sheriff's vehicle. No one had spoken to her. No one had said anything to her. The trooper came up, he looked at the scene, and then he decided to speak with my client. He never asked her whether she was driving the vehicle. He didn't ask her anything about the accident whatsoever. And all of this is recorded on his dash cam video that's part of the evidence in this case. He claims that he could smell an odor of alcohol about her person, and he claims that he could also see that her eyes were bloodshot and glassy, although he admitted that that could be the result of a number of things, including the fact that it was very early in the morning. Could have been as a result of people crying at some point, could have been a lot of things. He wasn't sure what it was. He then subjected her to a set of field sobriety tests, which he clearly had an obligation to perform in accordance with the National Highway Traffic Safety Manual for 2013, which was stipulated in the evidence. And the evidence is quite clear that he did not substantially comply with the terms of the manual, and then he arrested her for allegedly driving while under the influence of alcohol. He then took her to the Seville Police Department, where he attempted to have a test performed. She did not refuse the test. The test result was determined to be, quote, invalid. He then took her to Akron General Hospital, where there was a blood draw. However, one of the issues in the case was whether or not the blood test results were admissible, and the trial court properly excluded them. After this evidence was presented to the trial court in the motion to suppress, there was a brief filed by the defense indicating that there was no evidence whatsoever that was presented in this case to establish that Heather Sayler was in fact the operator of the motor vehicle in question. Obviously, the independent witness never saw who was operating the vehicle or how many people were in the vehicle, and none of the police officers ever asked her at all and offered no other evidence whatsoever that she was in fact driving the vehicle. So
Counsel,
yes,
what
Your Honor.
do you do with the timing of the call? Because the timing of the call is compared to what the officer who testified found when he arrived. And I ask that question because obviously there's direct and then there's circumstantial evidence. So the call goes out at, let's say, 5 5 o'clock in the morning, the 911 call. And then the officer who testified arrives at 5:10 and already finds her in the back seat of the cruiser alone, and there's nobody else there, and it's on the interstate. Is there a permissible inference that she was the sole occupant of the vehicle?
Absolutely not. And I'll explain why. First of all, the timing is that the gentleman who allegedly saw an accident, and we don't really dispute that he saw it, called at approximately 5:02 in the morning. Trooper Duda showed up at 5:15 a.m. And there is no evidence as to when the sheriff arrived, and there's no evidence as to what the sheriff found when he arrived. There's no evidence as to whether there was somebody else there who left. There's no evidence about another vehicle. There's no evidence at all. So there's many, many possibilities, one of which is that Heather Sayler was driving the car. That's certainly, I accept that that's one of the possibilities. However, it is not our burden to prove that, and it is not a particularly high burden for the state of Ohio to prove who was actually driving the vehicle, if in fact they had any evidence of it at all. They failed to call the deputy sheriff at the suppression hearing to ask him about the very issue, Your Honor, that you just raised.
If I may, Mr. English,
Yes.
whose car was it? Who was it registered to?
There's no evidence of that.
In any instance ever?
No evidence at the suppression hearing as to whose vehicle it was. And I've heard, I listened to or I read the argument that the appellee filed in this case, the brief, claiming that the court should or could reasonably presume that the registered owner of the vehicle was also driving the vehicle, citing a case that was decided by this court in 1993 called State of Ohio versus Kimberly Graves, case number 2202. And of course I read that case, and there are several other cases where the issue in those cases is always whether or not there is reasonable articulable suspicion to pull a vehicle over when there is a records check or a license plate check and it's determined that the owner of the vehicle has either a suspended license or no license or some licensing problem. And the issue, it's been raised many, many times as to whether or not that is a valid basis to pull someone over. But most of the time, if it's based on a license plate, there's no reasonable expectation of privacy on your license plate, and that's a database. And courts, including this court, have held that that gives rise to reasonable articulable suspicion. However, our argument at the suppression hearing is not whether there was reasonable articulable suspicion to show up at a scene of an accident. Of course there is. The real question is whether or not there was probable cause to arrest based upon one of the elements of the charge, which is that this person was actually driving a vehicle while allegedly impaired. That is something that the state of Ohio had a burden to prove by a preponderance of the evidence, and it doesn't get there by simply ignoring the issue entirely, which is exactly what happened in this case. There is no evidence whatsoever that she was driving. And presumably Mr. Bragg will argue that, well, we should just presume that that's the case, but unfortunately this is a court of law, and this is a serious criminal charge, and we don't just presume elements of a charge when it is your burden to prove by a preponderance of the evidence that someone was actually driving while under the influence of alcohol or had lost control of a motor vehicle while driving the vehicle. So the first issue that we raised in this case is that the trial court unfortunately just completely glossed over this issue. In fact, never even mentioned it in his decision, despite the fact that you will see from the record this issue was very specifically briefed in our post-suppression memoranda telling the court there is no evidence that she was in any manner operating this motor vehicle, and as a result the motion to suppress should be granted.
This is a memoranda that was filed before the court issued its ruling?
Yes, Your Honor. Before the court issued its ruling. As soon as that evidence came in, we were a little bit of a time crunch because the court conducted the suppression hearing, I think, about 7 days before the trial. And so immediately, and I mean within 24 hours, a memorandum was filed with the court setting forth our view of what the evidence was. At that point, there was a whole issue about the admissibility of the blood test. That was briefed extensively. There was an issue about compliance with the NHTSA manual, which was also briefed extensively. And the very first and foremost point was, Judge, there's no evidence that they proved that she was driving this vehicle, and therefore you can't reach this question.
But is that really relevant at a suppression hearing?
Yes, it is.
Well, let me just finish.
Okay.
Because the issue is, you know, she was operating a motor vehicle. And that's not really a suppression issue. That's more of the element of the offense that has to be proven at trial.
There has to be probable cause to believe that a person violated the law. One of the elements of probable cause is, Your Honor, that you actually were there. You actually did some act. It is definitely an element to be proved at trial, but it's unquestionably an element to be proved at the suppression hearing when we argue there was no probable cause to arrest. Even if this woman was completely falling down dead drunk on the side of the road, that doesn't mean she was driving while under the
Well,
influence.
that's absolutely true, but I guess you just said, you know, that one of the inferences that could be made was since she was the only person there, that she was driving the car.
Well, I didn't say that it was a permissible inference.
Okay, I'm
I
sorry.
said it was an inference.
Okay.
I suppose you could infer a lot of things. That's certainly one of them, but that's not evidence, Judge. You can't just assume. This is more, I would say, instead of an inference, it is an assumption that because someone is in a police car at the side of the road, that he or she was driving?
No, I'm just going to probable cause. I haven't gotten, I'm trying to, I thought at first we were talking about trial as a sufficiency argument, but you're talking about probable cause for the, at the suppression hearing to even go forward with the test or anything else, so, or for the arrest. So obviously that's a much less burden, probable cause.
Agreed. It's not proof beyond a reasonable doubt. It's simply a preponderance of the evidence. But there's got to be some evidence for which there is a preponderance. And my argument is that there's no evidence. And the only potential evidence that there could possibly be is some impermissible inference that because she was the only person at the scene at the time when Trooper Duda arrived, she therefore must be driving, or must have been previously driving.
You are in your rebuttal time, you can say that.
Let me raise one more
That's fine.
question.
Go ahead.
With respect to the NHTSA manual, I'll try to do this in 30 seconds. The court, of course, has looked at this manual many times, I am confident. And the manual exists for a reason, and the case law in Ohio, even though Holman was legislatively overruled, nevertheless still provides that there must be substantial compliance with the terms of the manual. In order to prove that, it is not hard for a police officer to come in and testify to exactly what it is that he or she did in compliance with the manual to justify the probable cause determination. In this case, thank God, there is a video. And when you look at the video and you compare exactly what the manual requires the officer to do, it is clear that he did not comply, much less substantially comply with the manual. He went through the steps. He did the first test, which is looking for a lack of smooth pursuit, very fast. He did it much faster than it was supposed to have been done. On the second test, he got frustrated with her. She has a lazy eye. Heather Sayler has a lazy eye, amblyopia, so one of her eyes is not completely aligned. He got frustrated with her and said, "Do you really want to do this test?" And she said, "Look, I'm trying to do the test." He then, when he's supposed to hold the stimulus 4 seconds at a minimum at maximum deviation. The first time he held it for about 1 second. The second time he held it for about 2 seconds. And then he got frustrated and he came back and he held it once for 15 seconds, once for 5 seconds, but then never repeated the test, which is exactly what the manual says you cannot do. You must check both eyes in compliance with the manual both ways. And then with respect to the one-legged stand, which is the third test, he had her do this. She unquestionably did it. Unquestionably did it. And she never put her foot down, didn't do anything. He's got another officer at the side who's counting, and she puts her foot down at 29 seconds. And he tells her to put it back up, which she picked up. And then the officer told him, you can hear it right on the video, now she's at 30 seconds. So based upon that, the lack of substantial compliance, even if you find somehow some evidence in this record, some presumption that she was driving based on these facts, they did not comply with the terms of the NHTSA manual, and that evidence should have been suppressed.
And unfortunately, you're out of time now. Okay?
Completely?
Yes.
No rebuttal?
I'm
Okay.
sorry. You're like me, you like to talk. Okay.
May it please the court. My name is Norman Bragg. I am the City Law Director of the City of Wadsworth, Ohio. I do not ordinarily appear on criminal cases or traffic cases, but my Assistant Law Director, Thomas Morris, is on vacation this week, so I am appearing in this case on the oral argument. I was not present at the hearing on this, and I did not write the brief. I have reviewed the information in my file relative to the case. I do note that Judge McIlvaine did write out a full opinion explaining the rulings that he made in this case, and I think that's what I would rely on, as well as the brief that was filed by Mr. Morris. I think that, and I would argue to the court, that it is a permissible inference that this defendant was the operator of the vehicle in question, from the fact that she was found by the trooper she was with in the car of a deputy sheriff when the trooper arrived, and this was out on an interstate highway. There would be no other logical explanation for her to have been there with the sheriff's officer waiting for the trooper to arrive, and other than that she had been the operator of the vehicle.
Well, there could be any number of reasons she was there. She could have been a passenger. She could have been the only person left, the person, we see cases all the time where people are involved in accidents and jump out of the car and run like heck.
Well, I think it is a permissible inference, though, that she was the operator. I would note in the record that the testimony on this on page 52 of the transcript indicates that the officer was dispatched to a single, he said, I was dispatched to a single vehicle traffic accident in that area. Upon my arrival, I observed the Medina County Sheriff's Office had a unit there, as well as Seville Police Department also had a unit there. I was advised by Sergeant Schmoll of the Medina County Sheriff's Office, and at that point there was an objection by Mr. English, objection, Your Honor, hearsay. And Mr. Morris said, I'm not sure what he's going to say, so if there's an exception to the hearsay rule, I don't know. The court said, let's. The witness said, I can't backtrack. The court said, just don't say what he actually said. The witness said, okay. The court said, but what you learned and what he directed you, that's fine. And then the officer proceeded to say it was a single vehicle crash, one occupant. There were no injuries at the time, and I don't know if it will be hearsay. Question, sure, that's fine. What did you physically come to see when you got to the scene? Answer, I saw a white Toyota SUV against the cable median barriers. It had heavy damage on the front side. I also made contact with the driver, Ms. Sayler. She was in the back of Sergeant Schmoll's cruiser, patrol cruiser. Question, okay, are there any other roads or exits there that were around there? We were on 71, but was there any other exit that's right around there? Answer, exit 76 is near that area. So that's kind of how the testimony got into the description of the arrival of the State Highway Patrol Officer and his interaction with Sergeant Schmoll.
Now, when that testimony presumably was given on direct exam,
Yes, I believe so.
was the officer cross-examined about, because he indicates that he had contact with the driver of the vehicle, was he cross-examined and asked, well, how did you know she was the driver?
and that'll be sent to both sides, as well as we will release it electronically on our website, and you can look there as well. Thank you, gentlemen.